Good evening, everybody. How is everyone doing this evening? Welcome back. Welcome back to the Infamous Sylvia channel where we do a reenactment of what happened in the courtroom. So today we are going back to Miss Kibi. She's back on the witness stand, and now we are going to see what really happened in the courtroom. Now we're going to introduce our actors today. First, we're going to have our wonderful court reporter is being played by a newcomer named Miss L. Dennis. Hello, Miss L. Dennis. Hello, how are you?
Hi, I'm doing well. Thank you for asking.
Awesome. Next, we're going to have our own Miss Red Purple Couch. I was about to say red couch, but anyway, welcome to our Miss Cardi B's attorney. She has played so many different parts, but here she is, Miss Purple Couch. Hello,
Hello,
Purple Couch.
hello. How is you?
I doing well. Next, we're gonna play our next attorneys. It's Mr. Sabak today, played by our own Miss Timara, as AKA Miss Clay. Hello, Miss Clay. How are you this evening?
Hello, everybody. I'm doing good.
All right. right, guys, y'all know yesterday she played the judge and she did a rock star performance. And now we have Miss Melly Mel's in the house. Hey, Mel.
Hey, hey, hey,
Well,
everybody.
All right, and last but not least, our homegrown Miss Kibi, Tasha K, played by Miss Perspective Me. Hey.
Hey.
Hello, hello. How are you?
All right, guys, we're all ready to get started. Let us roll it.
all rise. United States District Court for the Northern District of Georgia, Atlanta Division is now in session. Judge William M. Ray, the second presiding.
Good morning.
Please be seated and come to order.
All right, so let's talk before we start talking about the videos. Overnight, we've had a related or additional, depending on how you talk about it, COVID issue. Juror number 15, Miss Richardson, who's the same juror who had, it is Miss Richardson, right? It is the same juror, right?
Yes.
Okay. The same juror who had experienced concerns because her son had COVID has overnight indicated that she has developed COVID symptoms, chills, coughing. Let's see what else. Sore throat. So, three of the main COVID indications. I guess the only thing she really doesn't talk about is fever. Probably has a fever, but she has chills and then headache. So she called this morning or texted this morning about what to do. And we've instructed her not to report today. The question becomes, what do we do going forward? And we can stop the case and wait for Miss Richardson and wait to make sure that everyone else tests, or that time indicates that they're okay. We've had no communication from anyone else that they're feeling sick. We could move forward with the trial and just let Miss Richardson go. We, in fact, instructed her that a decision would be made this morning as to whether or not we'd stop the trial or that we'd proceed. I don't know if we explained to her that that meant that she would no longer participate. I think if we consider going forward with the trial, I would probably need to alert the other jurors about her symptoms and ensure they're not going to feel as comfortable going forward. If everyone doesn't feel comfortable going forward, then I think probably at that point, our option is really just to take a break on the trial and come back. I certainly don't know how long this trial will take from this point forward. I'm guessing a couple of days of defendant's testimony. Does the defendant expect other witnesses other than their own representatives?
We don't expect that this time.
Okay.
No.
Okay. I would think at the it would seem to me it would be logical that we would finish with Miss Kibi today. Well, maybe not given that we're starting a little bit later, but within a day of testimony. It would also seem to me that to be likely that Mr. Kibi's testimony would not be that long, given that he's not accused of individually making any of the slanderous or alleged slanderous statements about the plaintiff. His role more seems to be from the business side of things. So that might mean that unless there's a real rebuttal testimony to be offered, that we finish with the testimony at least by the end of the day tomorrow. Now, tomorrow is Wednesday, so that would mean we would be arguing on Thursday and the case may be over by the end of the week. Of course, there's certainly a possibility of a second phase of the trial, but as I indicated when we started, my experience has been that a punitive damage phase does not last very long. It should be very quick. And I do give the right for both an opening statement and closing statement. And of course, you can call whatever testimony is relevant to the issue. So the end of the week might be a good barometer of when we could be finished with the case, or it could stretch into Monday. But I have not made a decision about what to do. I wanted to hear what y'all thoughts we should do. I will say this, that I am concerned about a pause if the jurors are comfortable going forward, because that just leaves more time for people to be impacted. And, a pause would probably mean a pause of at least 2 weeks. I'm not really sure what my schedule is. I have lots of trials on my agenda. I mean, I can adjust simply by not having a trial and then starting this case back up. It's not like we have to pick a jury, so we can just start back up whenever it fits. But in any event, what's the plaintiff view on what we should do with the information we have?
Could I just have a moment, Your Honor?
Your Honor, may we have like 5 minutes to discuss before we tell Your Honor?
Sure, sure.
Thank you.
You're Sabat.
I thought I was.
Oh, I'm sorry. Thank you, Judge.
Okay, yeah, we'll take 5 minutes.
Okay, thank you, Your Honor. Yes, thank you, Your Honor.
All right. When you come back in, we'll start.
Stop it. Whose turn is it?
Brief recess.
All right.
All right. So everybody is back into the courtroom. So back to the plaintiff. Ms. Motz, what is your suggestion or your client's suggestion?
Your Honor.
Ms. Moore, I'm sorry.
Thank you, Your Honor. So, when you had advised us about your prior case where a juror reported COVID like symptoms and you requested that he test, we feel like the best solution is to have this juror test immediately. Get a PCR test because if she's negative, we don't want to lose another juror unnecessarily. But if she's positive for the safety and health of all the other jurors, we know that they would all need to be tested probably immediately.
Did I tell you
If,
so?
huh?
I'm sorry. Go ahead.
Okay. If this juror tests negative this morning and there are places that could go to her home and do a concierge PCR test within minutes results, then we would recommend that we simply argue the evidence today. Allow this juror to recuperate overnight and resume in the morning. We agree with Your Honor. We don't want a 2 week break, but we also don't want to lose a juror unnecessarily if she doesn't have COVID. I mean, 2 days ago, Your Honor, I woke up coughing and I didn't feel well, and I obviously did not want to put anyone at risk. So I did a test at home. I was negative. And then I felt better within 24 hours. There are lots of bugs going around. So I feel like the primary question is, does this juror have COVID? She needs to get tested. And I think after we know the answer to that, that would dictate whether the other jurors need to be tested.
So if she tests negative, you suggest what?
If she tests negative, Your Honor, if she's not feeling well, I think we would agree the evidence, the issues today, and we will argue the evidence and the issues today and resume testimony before the jury tomorrow morning.
Okay, that's not, your suggestion is not consistent with CDC recommendations.
If she tests negative,
Yeah, even if she tests negatives. The CDC does not recommend that they resume normal activities when they're still feeling bad because of the fact that tests are not 100% positive. So if she tests negative, then we've got to pause no matter what, as long as she's got symptoms. And the symptoms she's described are not the minimus. I mean, it's not just a cough. It is chills, and that's not normal with a cold. Not that I'm not a cold as we know it before COVID, but it certainly is consistent with COVID.
one question, Your Honor, too. Has there been, and I don't know if this has happened yet, has there been a situation where a juror was ill, not COVID, and they were put in a separate room watching on a camera? Has that ever happened in the courthouse since the pandemic started?
Hmm. I mean, it's possible. I suppose that we could do that. I mean, from a technology standpoint, we had originally made plans that there could be an overflow, an overflow courtroom, but that would be broadcasting. Let me ask Jennifer, what would, if we had done that with the general public, would there have been a separate camera where they would have been seeing everything from a bird's eye view kind of thing?
Yeah, that camera, and that is capturing the room, the audio, and then she would be in another courtroom or another room.
And it would just be the camera's view of everything, right?
Yeah.
Okay. Oh, so for example, if there were documents that were placed into evidence and shown on the screen, that would not show up for the juror unless that camera happened to pick up another monitor somewhere.
Right. there would not be a way to project.
Mm. So that's not a perfect substitute for being in court. Can't tell you. I don't think any of us really know that if anybody objects to that, whether or not or how. Yeah, nobody knows exactly what the 11th Circuit will say about that procedure. We're kind of operating blindly, and I recognize there are courts around the country that have had trials remotely. There may be one in Georgia that's done it, and state court in Fulton County that I think I may have read something recently about. I don't know. That's where I want to go. I certainly can't do that unless y'all agree. I'm not willing. I'm more likely. Well, I'm more comfortable with a pause than I am having normal procedure and then having somebody who doesn't like the jury verdict arguing that the delay was inherently prejudicial in some way because I feel pretty certain that the appellate courts will say, nope, we have long trials all the time, and there's evidence that's presented months before we get to closing. And as long as the lawyers are given adequate time to have closing argument to remind the jurors of all the evidence they've received, that's good enough. So to me, that's more tried and true than putting the juror in another room. Anything else you want to say, Miss Moore?
No, Your Honor.
Okay, all right. What about the defendant?
Your Honor, I think that we would be more most comfortable with a pause only because if the juror does have COVID and they've been all in close contact with one another, even if today nobody reports symptoms, what if someone has symptoms tomorrow? Then we would inevitably have to pause at the point in time. So, what would our preference in order to not lose any juror at this point? To take a pause and to make sure that you know, because if we let her go and then tomorrow someone else reports that they have COVID symptoms, then we're going to have an inevitably pause and the trial tomorrow. So since we don't know whether someone will or won't feel symptoms because they were in close contact with this juror, that would be our preference. So as to not lose any of the juror members.
All right. Well, I'm not going to decide right now. I want to talk about the videos and I want to think about it. I might be leaning towards letting the juror go and going ahead forward because I do have 9 at this point and I only need 6. I made my decision independent of who the juror is. Y'all may have certain, I don't know. I don't know anything about this juror other than she lives in Gwinnett County. So y'all may have fixated or determined, I mean plaintiff and defendant from a plurality standpoint or plural, that this would be a good juror for you. That's not my concern, whether she's a good juror for you or not. My concern is making sure we get through this trial and that we have sufficient jurors in the pool to make a decision. So let me think about it, and the jurors won't report for another hour, and I'll have an answer to you when we get through with our discussions about the video. All right. So all I know is that plaintiff thinks that there's some issues and the defendant disagrees. That was the last communication I had. I guess the emails that y'all exchanged with Miss Lee last night. So let's talk about it. So I guess we'll just take items one by one. Let's talk about the first issue that you have, and then I'm going to want to see it on the screen. Someone is going to have it ready to play, and I'll hear from the plaintiff and hear from the defendant about why this is appropriate or not. Let's see. And then I'll make a decision after I see that video.
Sure, Your Honor.
I was muted, sorry. Sure, sure, Your Honor. Is it okay if I go ahead and start?
Sure, since you're objecting, they want everything in.
Okay. Yes, Your Honor. And just so you know, we appreciate that Your Honor gave us the opportunity to look at everything again last night. Some of the videos that were on the list previously had been edited by them, and we had gotten those yesterday morning, but there were still many issues with them. So we appreciate that as an initial matter. So the first thing is, The first video is D11, which is the one we were talking about where we ended yesterday. So when we reviewed the video, there are still references to this alleged assault in New York in there. If Your Honor will recall, at the prior pretrial conference, this had been the specific subject of one of our motions in limine. And just so you know, the relevant portions of the transcript are somewhere around pages 38 through 48 of the prior pretrial conference. And the I'm just saying this to refresh your honor to the extent that it's helpful. But we'd obviously argue that any mention of alleged criminal activity is both not relevant and highly prejudicial here, which your honor had agreed with. We had actually said there's, almost nothing more prejudicial than alleged criminal conduct. And this doesn't have anything to do with the case. So Your Honor had ruled it out. The argument that the other side had made at the time was that this somehow showed that Miss Kibi made positive videos about our client because they alleged that she had made a prior video about these criminal charges, and she was saying she didn't believe them. And that was what Your Honor had specifically ruled out at the conference. This video, the clip is still there, the clip discussing this prior video. At the last hearing, the discussion that we had was they were trying to make that this was somehow relevant to the issue of rebutting that Miss Kibi has rebutting an argument they thought we were making. They thought we were going to argue that Miss Kibi has never said anything positive about our client. That's not something we've argued. That's not something anyone has ever articulated. And what the court said was, even if that was an argument, that you still thought this would be very prejudicial. So from our perspective, having this clip in there is still continuously prejudicial. And Miss Esmalova at that conference had even offered, because you had asked her if they had any other examples of positive coverage to make this point, and she said they did. And yet they're still trying to introduce videos with this conduct discussed in it. So I'd like to go ahead. The specific clips begin at 27. Well, the clip about the criminal conduct is actually at 29:56.
Whereupon a video recording was played.
I can hardly hear it.
Sorry, Your Honor. Technical glitches.
Whereupon there was a pause in the proceedings.
Oh, that wasn't the right time code, Your Honor. He was just testing the sound.
Whereupon a video recording was played.
All right. Thank you, Ms. Zola.
Thank you, Your Honor. First of all, the criminal indictment, whatever the criminal case that Ms. Matz is alleging or talking about, didn't come down until October of 2019. This video was made in September of 2018. So a whole year before any criminal anything was going on. The reason why this is relevant is because this was discussed already in the Star Marie Jones interview. First of all, that the jury has already heard and there was no objection to. And it goes to my client's state of mind and whether she does or does not have actual malice. She's not saying anything about criminal charges or indictments or any of those things. In fact, what she's saying is that anybody said something about the plaintiff that was not true.
What difference does it make whether there were criminal charges or not? It's the conduct that matters, right?
And she doesn't discuss that conduct. She's saying the conduct is false. That whatever.
Look, I understand, but the conduct itself is the issue. I understand your client said on the tape that she didn't believe it, but the prejudicial information from the jury's perspective would be the allegations that the plaintiff engaged in some type of assault, not whether or not the prosecutor agreed and decided to bring charges, just whether or not the allegation was there. So she is discussing the allegation, which was that the plaintiff struck somebody somewhere at a bar or a club or something.
As I recall specifically, we discussed that we were not to mention anything about any criminal charges or criminal history or anything related to gang activity, which we have not done and she does not do in this video.
I would say your interpretation of what we talked about is very generous to the defendant's view about what she can get in. You're obviously trying to get into evidence the allegation that the plaintiff struck somebody. Now you're saying that, well, the reason we're trying to get it into evidence is to demonstrate that the defendant has no ill will towards the plaintiff because she defended the plaintiff.
Correct, but that's not.
No, but the allegation is still coming in, and the allegation is that the plaintiff struck someone. And this jury isn't going to be charged with deciding whether or not the allegation is true or not true. And
Mm.
so, they won't have an appreciation about whether or not the plaintiff ever did strike someone or not, because that case isn't being tried. There
Wow.
would be no evidence of that one way or the other, but there's still going to be an allegation in that she did. So whether your client believed or disbelieved doesn't matter, whether it's true or not, right? Because Ms. Kibi doesn't get to decide whether or not the allegation is true. But it's being thrown in there. And at the end of the day, I still have to consider Rule 403 of federal rules. The probative value that you submit is that it backs up the defendant's claim that she has no ill will towards the plaintiff. And of course, I would argue this point that whether or not she has general ill will isn't the issue for the jury. The issue before the jury is going to be if when she said what she said that she has sued about, whether she had ill will and malice about those things, not about something else that's unrelated to those
Mm,
things alleged in the complaint. But
mhm.
under Rule 403, the court may exclude relevant evidence if its probative value. Here, you would say this part of the video supports the defendant's claim that she didn't hate or have malice towards the plaintiff, that she didn't hate, have malice, that it's substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues. Those are probably the two factors that are most implicated. There are some others. And the plaintiff's argument is that it would be unfairly prejudicial to the plaintiff to introduce the allegation made by somebody that she struck someone on a different occasion, and that it would confuse the issues before this court and before the jury. So,
Your Honor, no one is going to get over there and argue about this, you know, this allegation. It is in the video. She says it in passing. I mean, it ties in with Miss Jones saying, it ties into what Miss Jones was saying. And the reason why she even made the her initial viral video was because she stated in her interview, which was already the jury already heard that the plaintiff had an altercation with another singer, and then they talked about how she also had an altercation with those other two females. That was the whole reason why Miss Jones got on the internet to begin with, to discuss the plaintiffs and her past with the plaintiff. She
one person needs to talk at a time. Did you forget that rule? Did you forget the instruction I gave you that if you want to say something, you write it down? You do it again, sir, I'm going to hold you in contempt.
Woo,
I'm just telling you right now, I'm tired of it. You
woo.
act like you never tried a case that have judges, that have rules that you have to follow. They're not optional. All right. So anything else you want to say, ma'am?
I mean, I would like for us to be able to present our defense. What's That's what I would like to do. And so it's feeling like,
Well, your client can testify that, hey, I've defended Cardi on other occasions when there have been allegations made that I didn't think were proved, right? She can say that.
sure, she can say that. But what if the jury thinks that she's just saying that now because it's in her benefit because she's testifying and not, and she didn't. But when she have evidence that she said it two or more or three years ago, I feel like it's a different way, you know, to to the jury because the credibility is ultimately at issue the whole time.
Miss Motts, Miss Mott said that you said at our previous pretrial conference that you had other ways that you could introduce the same point, that your client had been supportive of Cardi on some occasions. Is that right?
When we were discussing not talking about criminal indictments, yes, but because there was other videos that we had that were obviously not introducing now because of the pre-trial, ruling. So
Well, that was the point of our discussion. So you're saying this is the one and only video you've got where she's ever said something supportive of Cardi?
I mean, I don't know. Out of all the videos she's ever made, I don't know.
Oh my
But this is the one that we were planning to use
Okay,
But
on
you just
you.
said that you okay.
I
Okay, guys,
understand.
listen. Hey, hey, hey. Could we not talk in between it? Because they're having a
I'm
hard
sorry.
time hearing everything, guys. I apologize, but Sabak is being played by what's the name? Perspective.
Perspective.
Okay.
Okay.
All right. Go ahead. I'm sorry.
Right, I understand, but you may not be able to use it. So are you telling me you don't have other videos where your client said something supportive of the plaintiff?
The other video that we were initially talking about was the video that Miss Kibi references in the video, where she said, "Do you remember 2 weeks ago when I made a video clearing the clip we just heard?" Miss Kibi referenced to a video she made 2 weeks prior to that video. That's the video that we were talking about, and that's the video that got excluded at the pretrial conference. So that's the video that we are not showing. This video is relevant because she goes through all the documentation or whatever that she receives regarding the Star Marie Jones story, and in passing saying this as she's talking about all the people that she spoke with, you know, to corroborate Star Marie Jones' story.
Relevance isn't the only factor.
Mm.
Prejudice is also important. So you're saying that this video that I just looked at and the one that is referenced in this video from 2 weeks before this video was made are the only two videos you have of the plaintiff saying, of the defendant saying positive things about the plaintiff?
I mean, I think she said positive things about her in the MLK video that they've already heard, or at least she said that she came to her defense in that video.
Right, about the skit that the plaintiff played.
Correct.
Coretta Scott King. Okay. Anything else? Is that all? Those three then? Those three then?
Yes, to my knowledge, those are the three videos that we were focusing on.
Okay. Anything else you want to say before I go back to the plaintiff?
I'm sorry.
Anything else you want to say before I go back to the plaintiff?
No, no, not about this. No.
All right. Miss Motts.
Yeah, so I was going to point out that they already did introduce one other video, the MLK video, that they tendered at least with the defense of my client in some way, shape, or form. This was the exact conference about the motion in limine. So we already excluded the video where she goes through it at length. I don't think that it is fair to let them just throw in another video that contains highly prejudicial allegations. And Miss Ismailova represented at the last conference that Miss Kibi had made positive statements about my client's music and other things. So to the extent that they've prepared their case to try to introduce evidence that are extremely prejudicial to my client, I don't think that that's fair. If they have other evidence, they can use it. And I agree with Your Honor. She can testify and say, without talking about what those allegations were, that she has defended my client in other videos.
Okay. What about Miss Amalaza's statement that Miss Jones' interview references this exact same, that's already been admitted and played for the jury, references the same exact incident?
That's not actually my understanding of what the Jones video referenced. What the Jones video referenced and what Miss Kibi's testimony yesterday actually was that Miss Jones made the video because there had been some sort of a fight at a fashion week with Nicki Minaj. that that has nothing to do with the alleged assault that took place with these bartenders. That has nothing to do with it. And there aren't, to my knowledge, there's not any type of, criminal indictment that stemmed from it or anything along those lines. I don't actually even know what happened. But to the extent that it was highly relevant to the one issue, the Nicki Minaj thing, that's, first of all, I'm not really sure that
And Nicki Minaj is another performer, right?
yes. And I'm not sure that should have come in yesterday, but either way, that doesn't open the door for them to continue to bring in other prejudicial allegations concerning criminal conduct where there's very specific, ugly allegations made and just leave it hanging for the jury. It's extremely confusing.
Right.
It's extremely prejudicial.
Right, let me see the conversations. Let's cue up Miss Jones' interview with the defendant and show me the part of it where they talk about this incident.
Your Honor, I'd also, to the extent that it's helpful from yesterday's rough, this is Miss Kibi's testimony. All right. Can you tell me how you first heard about Star Marie Jones? I believe it was New York Fashion Week. Cardi B had attacked Nicki Minaj at an event. Who's Nicki Minaj? She's another artist such as Cardi B. Is she on the same level of Cardi B, such as fame and popularity? That had nothing to do with any of this.
Well, I'm just trying to see if what Miss Ismailova just said, whether she's got any fact in what she said or whether or not she's mistaken. So let's
Olga.
I'm sorry, I was muted. Do you want us to?
I want you to play the part where they're talking about, and I guess it's going to be probably pretty close to the beginning.
I've got it. Don't worry about it.
Upon a video recording was played.
That was she said the two bartenders, which is the same two people that Miss Kibi is talking about in the video we just watched previously to this. And Nicki Minaj is a separate person.
Okay, play that again for me. This is the only part of the tape where she talked about it.
No, Your Honor.
I think she talks about the Nicki Minaj fight at the beginning as well.
Seems like maybe she's talking about two different things there at the same time. Let me hear it again.
Yes, sir.
Whereupon a video recording was played.
So is that the allegation in the New York incident
That's the New York incident that she's.
about a shoe being thrown?
Yes, sir.
I don't think that that's actually true. I think the allegation, I believe, is yeah, the shoe has to do with Nicki Minaj. The allegations in the New York criminal matter are that
There's been an accusation or an indictment there?
for Nicki Minaj,
No, for your client. Was she accused or indicted of?
there's pending criminal charges, Your Honor.
Not from New York Fashion Week, though.
No, not from Nicki Minaj incident.
Right.
So the allegations in the criminal indictment stem from an alleged beer bottle being thrown and two other people, not my client, getting into a physical altercation. And there's been an altercation that my client was somehow involved. An allegation that my client was somehow involved.
There's been an allegation that your client what?
Was somehow involved.
Okay, let's go back to earlier. You said this was talked about by Miss Jones earlier in her.
I believe that the time she mentioned the two other people was right here, what we just heard, and about the two bartenders. I believe that she spoke about the Nicki Minaj incident earlier in the video, which are two separate incidents, Your Honor.
Okay, well, that's consistent with what the plaintiff is saying. So was Nicki Minaj involved in the incident at the bar?
I don't believe so.
No, no, Your Honor.
I can't make heads or tails out of what she just said. It sounds like to me she's merging two different incidences into one because she references Nicki Minaj when she talks about those two bartenders.
Your Honor, she also just so you know, I don't necessarily think that clip should have been included in what they showed, but what she also says here when she's referencing the bartender alleged situation, she says them. What she said was most likely entirely innocuous, and I don't really think the jury is going to pick it up.
Well, I can't understand it. That's why I'm asking questions about it. I don't know what happened there, but I also know this, and that is that to the extent that the defendant even wanted to, excuse me, to the extent that the plaintiff, if this comes in, even wanted to address it, and I guess if it came in, she would have the right to. Well, I'm not sure her lawyers in New York are going to be happy with that. I mean, she's got a Fifth Amendment, right? Not to testify, but yet, if she feels like she's got to testify about it in the civil case, so that she can say, assuming that she would, that she didn't do anything wrong in the bar in New York, then whatever she says here would be likely admissible in the case in New York. And it's not fair for the plaintiff to have to make a decision in the civil case in dealing with a collateral issue at best that could compromise her rights under the United States Constitution and pending charges in New York, which is one of the reasons why when an allegation of criminal activity against a person has been filed, and then there's also civil action pending, that the civil action is stayed until the criminal action is dealt with to allow the person who's alleged to have done the bad thing to have no risk of their freedom associated with the criminal prosecution
Mm.
affected by their ability to testify in their own case or the case brought against them in the civil case. So I understand the defendant's argument that it's relevant. I don't think what she said in this Jones interview would make what would be revealed in the video today harmless. I think it would be harmful to the plaintiff if the video was played, which was why the original decision was made by me that it wouldn't come into evidence. Whether we're talking about criminal charges or not, criminal charges are just one part of the incident. That's what a prosecutor is considering or has filed bases the facts on the incident. It's the incident itself that raises negative implications about the plaintiff that are unrelated to the allegations in this lawsuit and are only collaterally involved because the defendant says, well, I defended the plaintiff against those allegations in New York that she engaged in some wrongful behavior. I'm not dismissing that it might be relevant, but it's more prejudicial to the plaintiff than relevant and necessary for the defendant. The defendant can certainly testify that she said positive things about the plaintiff. Should the plaintiff argue or intimate that that's not true, then maybe it opens the door for the video to come in. In any event, it's really irrelevant to the issues about whether or not when she said the defendant said what she said that constituted malice because malice comes from the event itself. Yeah. You can prove I generally hate someone, and that aids a juror in being able to determine when you do something that is slanderous, whether or not you had malice when you did it. But just because you may not generally hate someone doesn't mean when you engage in slander that you didn't have malice at the time.
Mhm.
I also think, based on the evidence, it seems so far that it would be a stretch to argue that the defendant generally likes the plaintiff. If so, then you need to question who your friends are because the allegations here that have been embodied in the videos that I've been shown, in my mind, demonstrate the opposite of that. So I'm not letting that video come in as it relates to the discussion of the allegations in New York, the New York bar incident. It certainly would, in my mind, uh, exclude would be excludable under Rule 403, and that's the court's order. All right, so let's talk about the next one.
I just want to be clear. You're not letting that portion of the video come in, correct?
I'm just saying, any discussion in any video about any allegation that the plaintiff was involved in any way and an assault or attempted assault in New York is prohibited, cannot be discussed. Other than that, I haven't seen no video. We're just talking about the portions. What's next from the plaintiff?
Thank you, Your Honor. The next two time codes, and I'm trying to deal with these in grouping. So there was one before that we can go back to in a moment, but the next two time codes deal with this same issue at 3709 through 20. Ms. Kibi makes a comment about this same situation and the same at 3938 through seconds 42.
Okay, I don't need to see any more about any discussions related to the New York incident. Anything in reference to the New York incident cannot come into evidence in this video, period.
Okay, thank you, Your Honor. So then the other two clips from this video that we objected to relate to a different issue.
Okay.
And these relate to the ruling on the motion in limine that the defendants would not be allowed to try to put in evidence related to their counterclaims that Ms. Kibi was being stalked or harassed or bullied by my client related to her counterclaims of assault and intentional infliction of emotional distress, which, as the court is fully aware, were dismissed on summary judgment. And because there was absolutely no evidence to support them. So the first,
Okay, that's a little broader. There's evidence to support, I have to take the allegations as being true. There's evidence to support that maybe she was stalked or bullied, but the court's ruling was that there was no evidence that it was linked to the plaintiff, that it was speculation as to that. Okay. But be that as it may, you want to play those parts of the video for me?
Your Honor, if I may just, again, this video was made in 2018 before this lawsuit was filed. There's nothing.
So then what would it be relevant to then? What would the allegations of being stalked and bullied?
She didn't say that. All she said was Cardi B tried to bully me.
Before the lawsuit was filed?
Correct.
Okay. But what does that matter?
There was no counterclaim or any of that. That's what I'm saying.
Okay, all right. What evidence what is her contention? Her being Kibi's contention that she was stalked or bullied. What does that go to?
She didn't contend that she was stalked. I believe at the end she just says Cardi B tried to bully me to take the video down, but I'm not going to be bullied. That's all she says. You can hear it. Obviously, I'm not saying not to hear it, but but that doesn't have anything to do with her counterclaim. That's just a general statement.
All right. And it's relevant to what?
I'm sorry?
It's relevant to what? What is it relevant to?
To them going back and forth with one another before this lawsuit was even filed. She got some kind of, a demand for a redaction to retraction. Or retraction. That's what Miss Kibi was talking about. She was addressing it, as it relates to that.
All right. Yeah, all right. Well, let me see it.
Your Honor, I would just say that's all she said. She actually talks about physical threat. She says, ain't going to be no security when that, BITCH sees me. She can throw shoes and she'll throw fists and something, and then I'm a CrossFitter or something. So I don't think that that's the entirety.
Let me just see what it says. Thank you.
Sure. It's at 45, second mark, 25 through 44.
Whereupon a video recording was played.
All right. So I guess, is there another part too? Two parts to it?
Yeah. The other part was earlier. It's a related thing, and it's at 27:16 through 20. There's a very short comment about fans issuing death threats.
Whereupon a video recording was played.
That was actually a little longer than I originally designated.
I'm sorry. I thought you were playing another one. I heard you say something.
No, that was it.
That was it?
Do you want us to replay?
All right, help me understand. And I'm talking to Miss Ismailova. Help me understand what is. Okay, granted, that's in a video that your client did where she's talking about the plaintiff. Why is any of that important?
She's talking about why she's talking about why did Star Marie Jones do the interview. She said that she didn't say anything about Cardi B threatening her. She said that her fans were issuing threats. How does that have anything to do with her?
Well, who is it she's talking about when she, being your client, was saying that, well, I'm in shape, I'm fit, I do CrossFit?
I mean, that was directed towards the plaintiff. But I'm saying, like, so there is all this, like, so there's all this evidence that the plaintiff has, you know, goes online and communicates, tries to post stuff. And she's saying this in, like, as a response to the plaintiff's reaching out online and posting stuff online, that she's going to testify to these things, like this all is, they were going back and forth online with each other. My client was not the only one talking. She wasn't talking to herself. The plaintiff was reaching out and sending messages and responding to all of that.
Okay, and your evidence that that the plaintiff was sending messages to your client, is your client talking about that and saying the plaintiff DM me or emailed me or went online and said something to me directly? And so your client talks about that, but that's not what I'm talking about. I'm asking about why is it important that the jury hear your client in this video talk about that somebody was trying to scare her, and that doesn't and that and that don't mess with me. I'm participating in CrossFit, and or that Cardi B's fans are making death threats against me. I guess I don't understand what your argument is about, or don't clearly appreciate why that's important for the defense that the jury hear her say those things in the video.
The ending comment, that's, I don't think that it's not like it's important for her defense. I don't think that they're prejudicial toward the plaintiff. She's just really saying anything. But the part about the fans threatening, she's not talking about herself. She's talking about the Star Marie Jones was getting the threats. She's explaining, only heard a little bit of the clip. But in the video, she's explaining why did Star Marie Jones decide to do the interview, because they're going to get up and say in closing, like, Star Marie Jones wants to get clout. That's why she did the interview. So she made all this stuff up. Well, this is explaining, like, what my client knew at the time of why, what was going on with Miss Jones at the time she did the interview with her. How is that not important?
What difference does it make why Miss Jones said what she said at all? I mean, the question is, did your client have reason to believe that what Miss Jones was saying about the plaintiff was not true, so that when your client repeated and emphasized and provided a forum for Miss Jones to say the things again, that your client is responsible for any slanderous material?
It goes towards Miss Jones' credibility. That's why.
Jones' credibility as perceived by your client.
Yes.
Okay.
It's going to be one of the issues.
So play that part again about the death threats. I'm not sure. I think it was the second of those clips.
It's 27:16, Your Honor, and stop it around 20, please. It's very short.
Whereupon a video recording was played.
All right, anything else the plaintiff wanted to say? Because I talked to you before I talked to Miss Ismailova.
I think the only other thing I would say is that I also, if that is the argument here, I'm also not sure that Ms. Kibi has competency to even testify about it. It's not even what Ms. Jones said. And I would just,
Okay, she's got competency to testify about why she believed what she believed or why she said what she said, right? I mean, she can't talk about why I did what I did. I did what I did because of what I was told was happening, or
Yeah, I guess you could say that. I do not want it to then launch into the other situation and
the bar situation.
the other alleged situation where I don't want this to become where when Miss Kibi is asked about this comment, if she is asked about it, that she talks about the other things that were discussed as a matter of counterclaims. So I think the death threat is mainly the issue because that has been very clearly, those allegations have been very clearly ruled out by the court and are not relevant to this.
The ones against the death threats that the defendant she received, I guess, right?
Alleges, yes.
All right. Okay. I don't have a problem with either of these two clips. I don't think that they're prejudicial to the plaintiff at all. And to the extent that they explain why the defendant believed Miss Jones, then that's what they show. I guess albeit for the jury to decide that. I don't think they're harmful to the plaintiff.
Your Honor, one more question about this particular video while we are still on it. There is a clip where it's about 39 minutes to 40, 39 minutes and 43 seconds where Miss Kibi does not say anything about the New York assault. What she says is, of course, Your Honor can hear it. Ain't nobody biased towards Cardi. I just cleared her last week, but she didn't give me credit for that. She's just trying to keep that monostat stuff off this channel. Now, just that clip is that she doesn't mention anything about, what she cleared her for or what, the assault or anything like that. If we take out the other parts that you have already heard about, is that?
That doesn't seem to really that doesn't seem really any different than her taking a stand and saying, I've defended Cardi B from other things that were said about her that I didn't think were true. I mean, it sounds pretty generic. What's the plaintiff's position about that? Maybe we need to hear that.
Sure. It's time stamped 39 minutes and 43 seconds. That's going to do it. They're going to do it.
Okay.
Oh, do you want us to cue it up? I'm sorry.
I want somebody to.
Well, we'll do it.
You said 39:42?
I've got it. It's all right.
All right, we're talking about in a video that has not yet been published. So we shouldn't be looking at this one, or is this one just on?
They're just switching my laptop, Judge.
Whereupon a video recording was played.
Has that not been played for the jury already?
No, sir. This is the video.
That part. So I guess because I've seen it, it just seemed it's familiar.
Well, actually, the plaintiff did introduce a clip of the video during their case in chief, but not the whole video. So maybe
But that part,
I don't know about that particular part.
I thought that was played personally, but
I don't believe I think we played the first part of that clip without the second part. We cut it off. I think that's why it sounds familiar.
okay, the wipe her rear end part, you stopped after that.
Yes, Your Honor.
Okay, so does the plaintiff have any concern about her saying generally I cleared her on another occasion?
No. I think as long as it's not connected up and they can't play those other two incidents, then I think it's pretty much the same as her getting on the stand and saying, I've said positive things about her.
Yeah, I do too. I don't have a problem with that.
I just wanted to make sure because it's technically talking about, it's technically referencing the.
I apologize. I think with the other two that it was on the list because it's continued repetition. But without the other two, I think it's probably fine.
Yeah, without the other two, you're talking about referencing the bar thing in New York.
Right. Because that is the reference. When she says I cleared her last week, she's saying again, referencing her earlier. So that's why I'm saying that one by itself, I don't think mentions anything that is different than what we were talking about. She could probably say on the stand, anyways.
Okay. Do you have any more clips to look or that you want to talk about?
Not in this video.
Okay. Another video?
Yes. Okay. And plaintiffs 525. This is a 2-hour call with Lovely T. We did play clips from this video. That's really only one part of this that's objectionable, Your Honor, and it's at 3802 through 3826. I believe the time codes that I put in my email. And this is, I apologize. I don't recall which of the women speaking on the phone said this. I think it was Lovely T said something about, or it might have been Miss Kibi. Cardi is starting to fight another woman for liking a picture on IG. They both cleared her name the week before. This is referencing the same incident. They both cleared her name of Miss Kibi and Lovely T are talking about how they both cleared her name the week before. People were saying that Cardi beat those girls up and put a hit out on those girls. Those girls didn't even get touched. We cleared the story. This is it's a short clip about the same incident that we've just been talking about in New York.
Mrs. Malova, do we even need to look at that?
No, I'll just take their timestamp.
Okay, that's out. I'm going to rule that out, okay?
Thank you, Your Honor. That's the only one in that video. The next one is D8. There are several problematic issues in this video. So two things. I'm sorry. Yeah, so this relates to a separate issue on the motion in limine. I'm just going to back up for one moment, Your Honor. This video, the title of this video, just so you know, is I'm sorry, Your Honor. Give me one moment. I want to make sure I have my notes correct here. Okay, I'm sorry, Your Honor. I had two videos mixed up. Okay, so D8, the first issue is that parts of this video talk about Nicki Minaj allegedly saying my client had herpes. This isn't, this is Tasha K saying that Nicki Minaj said it. And then they play a small clip of an alleged IG live from my client. There's a couple of different issues happening in this clip. One is that the defendant puts up internet evidence defining what herpes is in the middle of the video. And this is the exact type of explanatory testimonial evidence that Your Honor ruled should not be in these videos, where we had looked at some clips at the pretrial conference where they had definition of stripper hoe and all of these things up on the screen. And so
Okay, that was a little different. That was the defendant's attorneys adding definitions to things versus you're saying that the defendant herself put that up in the video when it was playing for the audience.
So it actually wasn't different. Those were just in whatever clips that they found wherever they took them from.
So you object to a definition of what herpes is. You're suing saying that they said she had herpes. Is it harmful that the jury knows what herpes is? Is it not a fair definition?
I have no idea where it came from. And I think it would be trying to bootstrap in some type of medical evidence that was taken off the internet from an unknown source. The other piece of this is that they are trying to play a video clip from my client where my client is partially speaking in Spanish and they're not putting in a translation. So there's very clearly, I think that piece was not authenticated. But even if they showed it, I think that there would have to be some of
I don't understand. That piece is not authenticated.
it hasn't been otherwise authenticated. But the issue is they didn't show it to my client in deposition or on the stand. But the issue is I don't think that they can just put it in without having some sort of a translation.
Based on what law? I mean, what is it harmful to anyway? Those are two different issues.
Yes, sure.
You don't know whether or not this video is what your client said, or you don't know what. Are you arguing that? Well, the jury's not going to see, the jury is not going to know what it means unless they speak Spanish.
Yeah, I think it's the latter, that the jury is not going to necessarily know what it means unless they understand the language that's being used because
which means it won't be harmful because they don't know what it means anyway.
Well, no, because it's partially in Spanish and partially in English. So what's essentially said in this video is my client says deca cold sore, which means they say I have a cold sore. Then she goes on to say, but nobody takes the time to look to see that it's a birthmark, etc., etc. And she says some other things in Spanish. So it's partially in Spanish, partially in English. And to the extent that they're going to use it to misrepresent that it was some sort of an admission that my client was saying, I have a cold sore, I don't think it's prejudicial without the jury knowing what that says.
Let's see the clip. Is that the full explanation of it?
That's that particular clip. So I think that this starts at 3:45 through 4:39. And I'm sorry, it's pronounced deque, Your Honor. I actually don't speak Spanish, which although I wish I did.
Whereupon a video recording was played.
I mean, I wasn't, to the extent that she was speaking Spanish there, I wasn't picking it up. I don't speak much Spanish and I wasn't paying a lot of attention to that. I'm sorry, if y'all would hold on just 1 second, please.
Yes, Your Honor.
Sorry. Okay, I've got to take this call. I've got a dog that's at the vet.
Whereupon there was a pause in the proceedings.
I'm sorry. I would normally take a call, but I had two animals that went under anesthesia this morning for teeth cleaning, and one of them, well, they were concerned that she might have a heart issue, but she didn't. All right, so I want to get back. I mean, as I was saying, the Spanish that was used, I didn't understand, and I didn't pick up anything from it one way or the other. Like I said, I don't know how, putting aside this chart issue, I'm not sure how I'm not sure how anything that's in there is harmful for the plaintiff, though. I guess when you say, well, they don't know the Spanish, and so it's hard, so it's kind of leaves all that out there for them to figure out. Of course, there's ways for that to be dealt with. Your client speaks Spanish, and I'm going to presume that there's nothing bad there. If there's something bad there, you should tell me. But if there's not, then she certainly can get on the stand if she wants and interpret it for the jury and say this is what I said in Spanish, which was innocuous. So that she doesn't seem to me to be that big of an issue. And then I guess the other issue is the chart, right? Those are the only two issues. The Spanish, you didn't have any problems. I'm speaking to the plaintiff's counsel. You didn't have any problems with what she said in English, right?
No, I guess because the mix is she always deque kosar, and then Miss Kibi says she's admitting she has a cold sore. But that decade means is they say I have a cold sore. So my problem is the mix without translation. And we do have a case on the translation issue. Ruiz versus United States that, party tendering evidence is supposed to do it in English or provide a translation. So I just think that you're right. We can put our client on the stand on rebuttal and have her explain it. But I think it's also, it is a requirement usually that when you're introducing evidence in another language, that there also should be evidence of what that means. And
They can call your client to interpret it for them if they want.
they could. I agree with that. But I think that that's not, and they didn't do that.
They're not finished. I mean, y'all can either stipulate what it means or they can call your client and testify to it. I'm not going to get hung up on a technical rule of evidence where there are workarounds that are legitimate, which is like calling someone who speaks Spanish to stand, who happens to be in a courtroom. You're trying to basically hang ribbons on technicalities that can be resolved. It's not even bad.
I'm fine with that resolution if they had called my client to do this. But my understanding is they just said they're not going to call anybody but Kibi and that they're planning on doing this with Miss Kibi without any type of translation.
Well, if you're going to object to this, then probably what they're going to do is call your client and have your client interpret it for them. I mean, they're probably going, if you don't object to it, they're probably not going to do that. This is a red herring. I mean, You're saying that it's not bad, but you're objecting because they haven't interpreted it. But they can provide an interpretation by calling the plaintiff to the stand, asking her what it means, or you can, by rebuttal, you can do that. Um, there's nothing harmful in it other than a situation that can easily be cleared up by, if you wanted to, um, if you really want to. You just want to keep out the video.
No, I'd actually be fine if it came in with, if they had shown it to my client the first time. I wouldn't be objecting to that.
Well, they don't have to do it the way you want them to do it. Okay? They can do it however they can do it, which is they can call your client to the stand. I can call your client to the stand and ask her to interpret it. Do you want me to do it that way, or do y'all just want to stipulate what it means, what she said?
I'd be fine with stipulating.
How about that?
Your Honor, that's fine. The stipulation thing. The reason why we're playing this video is not really so much for, it's just for what Miss Kiwi thought that was said. That's what she had, that's why she played that video, is because she interpreted that video to mean that. She's not trying to.
She interpreted the video to mean,
She doesn't speak Spanish, so I think she interpreted the video to mean that the plaintiff was admitting to having a cold sore. That's why she's playing that video within her video, is to show where she was coming from. So it shows for the state of, so it shows for her state of mind. We're not trying to, I'm not trying to talk about the, we're not introducing any.
well, how about this? Y'all either agree to a stipulation,
We can't agree to a stipulation.
either agree to a stipulation about what it is that the plaintiff said in Spanish, or if you're going to use that video, call the plaintiff to the stand and ask her what she said.
Sure.
All right. So let's talk about the chart part of it, though. Put that back up there. Let me see that again.
That portion of it starts at,
It doesn't matter. It was up there for a while.
yeah, I believe it starts at around 440. I think that's where that starts. Yeah, 440. It's up there from 440 to somewhere in the 6 minute mark.
So, what would your client say about this chart?
She's just saying that
Not as to what the video said. She didn't talk about the chart in the video. But if your client was asked about this chart, what would she say?
this is the definition of a cold sore that she replied on.
That what?
That
Wait a minute. That what?
Like what that like that is says that cold sores are herpes, because the whole thing is that they're saying that she is, alleging that the plaintiff has, genital herpes, which she does not allege. She always talks about the cold sores.
Well, I'm not going to require the defendant to take this out of the video. This is what they had in the video. This video, in part, I suppose, is part of the slander that the plaintiff knocks the defendant for. The defendant is able to say, this is what I relied on. Maybe it's reasonable to rely on this. Maybe it wasn't reasonable to rely on this, but this is what she relied on. So I'm not going to require that be taken out. Any further parts of this video, or is that it?
No, there's a couple of other parts.
Of this video?
Yes, I would go ahead and skip to 749 through 816, because it's honestly just a repetition of kind of what we just saw, essentially. So I don't think there's anything new for the court to rule on there. Okay, from 1110 through 1858, there is a long Miss Kiwi post or depicts on the screen a Facebook post that was allegedly posted by my client's husband's father. And
By the father of her husband?
yes, my client's father-in-law,
All right.
where he is talking about drugs in the household, feds kicking in his door regarding some type of criminal allegation that was made against my client's husband, and then talking about how,
Was the criminal allegation drug related?
He doesn't go into it.
Okay.
and I honestly don't think
What's the stage name or legal name of the plaintiff's husband?
Offset.
Offset. Okay. I've got Culture Down, which is pretty cool name. It's a pretty cool name. I've got to admit.
And then there's some commentary about how she talks about how my client released pictures of their daughter on Instagram out of spite and how my client is racist. And
I'm sorry. What's this? She put pictures of her daughter on the internet, or she released them? What's the problem with that?
because she says she did it out of spite and essentially because my client is racist.
She, being the defendant, says your client is racist because she released photos of the plaintiff's daughter or of the defendant's daughter.
Of my client's own daughter.
She released pictures of her daughter, and that made her racist?
That's the implication that the defendant makes. She goes into a long tirade about how, I'm sorry, Your Honor, some of this language makes me a little uncomfortable, talking about how, she doesn't like chocolate people and she doesn't like black people. That's a little later in the video. These are kind of connected up. And then there's in between, there are also posts, other social media posts that we have specifically moved to exclude that she puts up on the screen. They're totally irrelevant. There are other social media posts that have nothing to do with the allegations in the case, the interactions between the parties. They're just in our motion in limine, we specifically moved to exclude these because they're
Social media posts where the plaintiff and the defendant are communicating with each other or about each other?
no, not at all. Social media posts where my client is allegedly commenting on some other person's page. And Miss Kibi is essentially just ranting about how disgusting it is that my client is calling a black child a monkey. And these were specifically mentioned in our motion in limine, and they were specifically ruled out because they have nothing to do with this. This was part of the irrelevant social media evidence that we had a long conversation about. And so essentially, they had put those posts in physical form on their exhibit list, and they are in this video being discussed. So those are the kind of next three things.
This is all included in a 6 minute, 7 minute clip?
No, I'm sorry. I just summarized the next three issues because some of them were related and went back to the three issues. I can give Your Honor the exact time codes for which issues if you like.
All right. So let's isolate them if we can. So, what is said about, what is it about, what is it that the defendant says about, well, let's see the social media post of the father in law that you had problems with.
Sure. That starts at 11:10 and goes through about 1858, Your Honor.
It's a long post.
Is she talking about it while she's got it up on the screen?
Uh, yes, she's reading the whole thing.
Okay, let's just see it. I can read it.
Whereupon a video recording was played.
All right, so Ms. Ismailova, this whole part of the video, what would it be offered to support?
To support the corroboration that the allegation that plaintiff does drugs, because she's got on the stand already and denied that. This is clearly coming from, a source who knows the plaintiff. Also, it talks about the fact that, he mentions that they have professionals that they don't use, like therapists and such, even though there was testimony that, that she goes to therapy.
I'm sorry, I didn't understand that. It says they don't go to therapists?
That's what the post says. They have professionals at their disposal that they do not use.
So you're questioning Dr. Sherry's statements that she counseled the plaintiff over these allegations.
I know, based on the evidence that we have, I know that she counseled her for 4 times. Counseled her 4 times. I don't have any other document.
Well, whatever she said, how many times she said, she being Dr. Sherry, said that she had provided counseling to the defendant back both in New York and I guess here in Atlanta. I'm not clear about whether that was virtual or in person, but whatever she said, she said. You're questioning whether Dr. Sherry is telling the truth about that?
No, I'm not saying she's not telling the truth about those 4 times. I'm saying because plaintiff has an lie claim, IED claim,
Because,
I'm sorry, international infliction of emotional distress claim. And for me, our argument is going to be that's not 4 times or however many, the little isolated time that she saw. I don't think it's enough to prove, an international infliction of emotional distress, coupled with the fact that now her father-in-law is saying that they don't really use the professional help that they have around them.
I mean, that's some weird logic there. I mean, the plaintiff has testified that she got some counseling from Dr. Sherry. Now, Dr. Sherry testified that she provided some counseling to the plaintiff. I understand your argument that that's not enough to really show that she had the extreme, outrageous emotional distress that the tort supports, but I'm not real sure how this post does anything with regard to that and saying that they being Offset and Cardi B, have other counselors, I guess, available to them that they don't utilize. That doesn't seem to be in dispute because the plaintiff has testified to what she received and nothing more than that. The drug part, okay, maybe it's probably that it's a stretch to say that the father is definitely saying that Cardi B uses drugs. The words drugs are used in a very generic term or way. And he seems to be mainly talking about his son. But to the extent that you would say, okay, but that's what my client relied on to say that the plaintiff had a drug problem, okay, I don't know that I agree with that, the logic of her decision. But I see your point there. What else? What else would this post? I guess it was Facebook. What this post or text or whatever from the father-in-law support?
Yes, sir. Just to this video was made in December of 2018. So it also goes to basically explain like these things were going on in Plato's personal life. And he mentioned in there, things about depression and stuff like that. She said that she's depressed because of my client. You know, my client was the first person to do all these things or say all these things, but clearly she's having marital problems. There's
Yeah, okay. That is so legally wrong for you to make that judgment that you could
wow.
provide a hearsay statement
Mm.
from someone to support your claim that she was obviously having mental distress from other purposes. You would be using hearsay to try to negate the
Mm.
plaintiff's own testimony that she was having problems. That is classically illegally wrong
Mm.
under the federal rules of evidence.
How is it not impeach? How is it not impeachment testimony when she said that the only reason she's depressed is because of my client?
Because it's not admissible for that purpose, is why. If you brought the father in and he was on the stand testifying to what he personally knew and could be cross examined, then maybe. But you're not doing that. You're trying to use a hearsay statement written by someone who's not in court to try to counteract and counter argue the plaintiff's argument that was provided through testimony in court that she suffered mental anguish based on what your client said. You want to say, no, it's not because of what my client said. It's because of all this other stuff going on in your life. Well, how do we know about this other stuff that's going on in your life? Because it was written about in a post by someone who doesn't come into court and testify? It's not admissible for that purpose. You should have learned that evidence. You should have learned that in evidence class your first year law school. I mean,
Wow.
come on.
Wow.
I understand your argument as it relates to your client's state of mind when you said what she said. Cardi B uses drugs because, and how do you know, what did you rely on? Well, I relied on this post that I saw, but you can't use that post to prove the truth of the matter which was asserted in the post. I mean, that's classic hearsay. Look up the definition. Anything else?
No.
Okay, yes, ma'am.
I just wanted to clarify, Your Honor, that post is actually my client's stepdad-in-law. I misspoke. So I just wanted to clarify that.
Stepdad in law.
Yes, my client's husband's stepfather.
Okay, your client's husband's stepfather married to your client's mother, your client's husband's mother.
I believe so.
I don't know that that really changes anything.
No, it doesn't really matter. My point was that the post was actually, it wasn't even authored before the Star Marie Jones video. The Star Marie Jones video was in September. We're talking about something that occurred in December. So it couldn't have been
Continued to say all those things even after the post was issued, right?
most of them, yes.
I mean, I can't cut the legs out from under the defendant. The defendant says when I said some of the time that the plaintiff was doing drugs, I was relying on this post. Is that a reasonable interpretation of what was there? I don't know. I mean, I wouldn't say it based on reading something from somebody I had never met that may or may not have a relationship with the person for whom I'm going to say something about. I probably wouldn't be very sympathetic to that defense if I was on the jury, but I can't say that a juror might not be sympathetic to it and believe it. So I can't rule it out. But I'm not going to allow the defendant to argue that the things that the writer, the stepfather in law, said is true because he wrote it. If you argue that before the jury, I'm going to correct you in front of the jury in harsh tones. Look up the definition of hearsay. It's not admissible for that purpose. The only the only purpose it would be admissible for would be for at least some of the time when your client said what she said about drug use. This provided me with some reason why I might have said it, but then, of course, that gets debunked if, in fact, she had already said that the plaintiff used drugs before. Then, did she really rely on this? From a timing perspective, maybe she did on some of them, but the jury will have to make that decision. So I can't rule this post out. I think it's I think it truly shows the character of the defendant generally. I mean, I'll say whatever I want to say, whatever I want to say, whenever I want to say it, for whatever reason I want to say it, if it makes me money.
Hmm.
Mm.
So, but I guess my point is from that perspective. I think the whole video is arguably more supportive of the plaintiff's overall theme, which is that the defendant engages in slanderous conduct than it is a defense of the defendant.
Your Honor, could it be, could the ruling be, I mean, she does say the part about the drugs early on. Could it be split so that the second screens where they're talking about feds kicking in doors and guns in children's faces not come in?
She never says that about, there's nothing about that implicates your client in any way. I'm not going to make them chop it up for no reason. I mean, it's only very, it's only with a very liberal interpretation of that, of it, that it's even attributes drugs to your client. But I would certainly, I mean, I certainly didn't see anything else about that that would be attributable to your client. I mean, like the Fed thing was totally related to the son, the stepson, I guess.
I guess the only thing I'd ask is that Your Honor just give a limiting instruction to the jury regarding hearsay, similar to what you did with some of the comments when they were with our clients, excuse me, when they were with the defendant's post, that there just be some sort of an instruction that it's not being admitted for the truth of the things that are in the post.
What about that, Mrs. Malova?
That's fine.
All right. So alert me before you play this video,
Yes, sir.
and I will give a limiting instruction on hearsay.
Thank you, Your Honor. We appreciate that.
Okay. Anything else?
Yes, there are three more. I like to deal with the last few first because those are the ones I kind of described. This is completely unrelated and irrelevant social media comments where Ms. Kibi is accusing my client of being racist, where the comments themselves were actually already ruled out by the court. We can start that at 2224.
How long is it?
This one is 4 minutes, and then the next one is approximately 2.5 minutes.
Okay, let's just watch both of them and then we'll talk about them.
Whereupon a video recording was played.
All right, so Ms. Ismailova, what relevance does this video have to your claims in this case?
Did you want to see both, Your Honor? I'm sorry. I don't want to interrupt you.
No, I want to talk about this before I forget it all.
Okay, go ahead.
Well, there's been allegations made that my client talks negativity or reports negatively about the plaintiff's child, and she specifically here, only says positive things about the child. That
Talks about positive things about whose child? About her?
about the plaintiff's child.
What did she say that was positive about the plaintiff's child?
That she's beautiful, that she's, a pretty baby, that type of thing. But overall, also, I mean, it also explains why Miss Kibi does make, in general, like still a report on this plaintiff. I mean, she gives an explanation. She's a public figure. This is what she's doing. This is the behavior that she's, teaching to her fans who are young kids, young and kids. And so she explains all of that. And so,
Explained her logic for why she can say what she wants to say because Cardi B, the plaintiff, is a public figure?
not say what she wants to say, but she's saying that people, you know, there's people saying I'm harassing her, which is also what plaintiffs testified to, that, that my client was harassing her. She was harassing her friends.
Comments that she was making about her, right? That she was sued for?
Right. But this is also explaining her state of mind and what, why she's doing what she's doing. Like,
You think this video is good for your client as to your client's state of mind? Really?
yes, I do. Because she is genuinely saying what it is that, like, what she's reporting on and why she thinks whatever she thinks about the plaintiff. Yes, I do. And I think that the jury should see it because it goes to her defense.
Hmm. It goes to her defense how?
Because it explains her state of mind at the time that all these things was, this was this was in from this is from 2018, like I said.
This video explains your client's state of mind about what?
About the plaintiff.
In what way?
I'm not sure what the question is. I'm not
You
sure what the question.
said that it explains your client's state of mind about the plaintiff. In what way does it do that?
I mean, she just, like, this is part of what she thinks about the plaintiff and why she thinks those things.
She thinks the plaintiff is bad. She thinks the plaintiff is bad because she engages with a fan and said mean stuff to a fan. That provides a defense to your clients, to the claims that your client defamed the plaintiff, that your client believes that the plaintiff is bad because she engages with fans at times in a negative way?
I mean, I think I think that the jury should know that this is what, like, if they don't see all of the interactions of the full story, then how are they supposed to determine whether or not my client has actual malice towards the plaintiff or not? That's what I'm not understanding.
Your client is charged with saying things that are untrue about the plaintiff. We don't even get to malice unless and until there's a decision made that your client did say things that were untrue about the plaintiff. Then we get to, did she have malice when she said those things?
Right.
And this video we just watched would negate the client's contention that your client had malice. How? How would this video, in other words, negate that your client had malice towards the plaintiff when she said the things that were slanderous if we assume that they were for discussion purposes against the plaintiff? Would argue that it shows that your client shows that your client does have malice because your client has just ranted and raved about how she believes that the plaintiff engages wrongfully with her fans and says really mean things to her fans. Now, that might be the reason that your client said the things that she said that a jury may determine to be slanderous, but it doesn't negate malice. It actually supports that there was malice. I don't like Cardi B because she says racist things and she says mean things to other people, it sounds like. And I'm not personally trying to say that. I'm just trying to summarize the way I interpret what you're saying. And that to me is almost the definition of malice. I don't like her because this is the stuff that she does. And so I'm going to go out and say stuff that is not true about her. Now, I understand your client says that the things I said weren't true, but if the jury assumes that they were true or decides that they were true, then they move on to malice and they look at did she have maliciousness of heart when she said what she said. The video kind of shows that. It doesn't show otherwise. I don't believe in it. And then another question, I guess, is, well, if they don't decide the malice issue is whether she recklessly disregarded and reasonably relied upon the information she received, but you stand by your position that this video undercuts the malice decision that the jury may have to make?
I mean, I mean,
You've got to argue to a jury somehow, someday.
I know that, and specifically, maybe not specifically to those statements that we're talking about, but I think that it goes. I think that it will provide the jury like a fuller picture of what's going on at this time.
Well, it certainly does provide the complete picture of what's going on, but it's not going to both relevant and not prejudicial. And there is prejudicial stuff in it because the comments that were made by the plaintiff to the fan are not good. They're pretty abhorrent. You know, I think the jury could reach that conclusion. And so the question then becomes is, well, if those statements would put the plaintiff in a bad light, then does that outweigh the relevance? I'm not even sure I even see the relevance because you wanted to introduce it. I guess to try to negate the malice component of defamation, of the defamation claim. And I don't see how arguably they do anything but support the malice component. And the plaintiff doesn't want it in because it's prejudicial to how the jury may view her as an individual. And thus, if they don't like her, like your client obviously doesn't per the discussion here on this video, I recognize she could be performing and it may not be her personal views, but it is what it is. I don't know that any relevancy it has outweighs the prejudicial harm that would occur to the jury deciding they don't like the plaintiff because she may have said some things to this fan. That's why, I mean, you seem to be incredulous that I'm asking you, how is it relevant? Well, I'm asking you, how is it relevant? Because that's part of the test. And it's certainly not relevant to show lack of malice. And because I don't think a reasonable juror could look at that and say, oh, that shows it wasn't malicious. That shows that the defendant said what the defendant said wasn't malicious because it's not supportive of the plaintiff. It's actually very critical of the plaintiff. So I'll give you another opportunity. If I'm missing something, tell me about how it's relevant to the issues that the jury has to decide, because that's part of the 403 analysis, is that inherently that it's got to be somehow helpful for the decisions the jury has to make. I'm going to read 403 again. The court may exclude relevant evidence. I assume that it's relevant for the analysis that I'm doing right this second. If its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. And I think, again, that the issues here are unfair prejudice and confusing the issue. Maybe misleading the jury, but I'm not sure that's really implicated. So, anything else you'd like to say?
Well, the jury is also going to have to decide, damages and the intentional infliction of emotional distress claim. And for them to not know all at all that this is they should know the kind of person that the plaintiff is when they are determining whether or not she's been damaged. She claimed that my client, one of the things she said was that my client got online and, talked negatively about her daughter and her family. But this is the kind of things that she does. So how could she then turn around and say she's being damaged by this video or any other video that my client made when this is the kind of person that she is? That's the relevance for this jury. In my mind, I feel like they should see the fuller picture, because now it seems like only my client is just reaching out to the plaintiff and just here harassing her. That's kind of the story of the plaintiff, the story the plaintiff has told. Now it's our turn to tell our side of the story, and I feel like the jury deserves to know the full picture. I understand that, the criminal activity, the gang stuff that's not mentioned. We redacted this video. About half of the video has been redacted. And before yesterday, to take all that stuff out, but some of these things are still relevant for the jury's decision. They cannot just decide based on what they saw on the stand, because that was not the person that who plaintiff really is. I think that's not fair.
All right. Thank you. Yes, ma'am.
So essentially, what Ms. Ismailova is arguing is that they are trying to prove up other bad acts to honestly, quite frankly, to prejudice the jury and to poison the jury. I mean, we're talking about, first of all, this is her interpretation of what's going on. She says a lot of things that aren't even necessarily on screen. And then she's talking about my client, being racist and congratulating people on dead babies. I mean, it is so highly inflammatory. And I have nothing to do it has nothing to do with this case. We're talking about defamation allegations that Miss Kiwi made false statements that my client has herpes, has HPV, engaged in lewd acts with a beer bottle, and cheated on her husband. I mean, this is what we're talking about, and was a prostitute. Excuse me. I don't want to leave off the last one. We're not talking about this other stuff. This is totally irrelevant. And for them to be allowed to introduce everything my client has ever said on social media, when they are literally picking the most highly prejudicial examples and to intentionally poison the jury, is completely and fundamentally unfair.
So, what is the other part? The other video going to show? Similar kind of stuff?
Yeah, it is. And you want, if this is a,
I'm going to want to look at it. So, let's go ahead. Let's look at it now.
sure, it's 27:45 through approximately 29:38.
I'm looking for, whereas a video recording was played.
Okay, hold on a second. If we can let the jury, it's 12:30 now. We've got this clip and there's one more to look at. Is that right? Is that right?
There's a very short one in this video, but then there is another longer video that is has a lot of other information in it.
How long is it?
I believe that one, honestly, we're objecting to the entire video, and it's 18 minutes long.
18 minutes long.
Yeah, 18 minutes long.
Okay, let's excuse the jury till 1:30, and I'll apologize to them when I see them. Won't make them feel any better, but all right. Let's go ahead. I'm sorry.
Whereupon a video recording was played.
All right. So, Miss Ismailova, what does this go to? This whole discussion. It seems like the overriding theme is that plaintiff doesn't like black people.
Right. So it also goes to the motive that of what she sued Miss Kiwi. We already talked about this.
Motive of why she what?
Why she, sued Miss Kiwi. She was before this. This was before this lawsuit was filed.
That she sued Miss Kibi
She doesn't like her. I mean, that's what she said.
because she's black,
Because she doesn't like her.
because this video came out.
Well, not just this video. Obviously, there's been other videos.
I'm sorry. I don't follow. So your argument is that she's really is not slandered or damaged, but that she just doesn't like her because of the fact that your client put out the videos, or because she being the plaintiff, doesn't like black African American people?
That she doesn't like black people, and also that because she can't put her hands on her, that she was that the was the whole, the other videos were already discussed.
Well, that wasn't in this video, right?
Not by video. That was a different video. Not yeah.
She doesn't like black people because your client says in your client's video that she doesn't like black people.
I mean, she
So this is proof. This is video proof that the plaintiff doesn't like black people because your client said it.
she's not just saying it out of nowhere. I mean, she's basing it off stuff that the plaintiff has posted previously on and other interactions she's had. This is not the first time that my client says it, because it's not.
Okay, all right. If we assume for a minute that your client is entitled to prove that plaintiff doesn't like black people, that's somehow an element of the case. Can we agree that your client doing a video and saying that the plaintiff doesn't like black people would not be admissible for the proposition that the plaintiff doesn't like black people? I remember when I was in law school, I was not on law review. I did moot court and mock trial instead. But my roommate did law review. And I can remember him bringing me a note his first year in law review where there was a certain professor that we didn't like. And he was reviewing a law review article that the professor had written, where the professor was making a statement and he was citing his proposition for why the statement was true. A letter to the editor that he himself wrote. And it was published in the New York Times. And he thought, what a joke that is, that you can say something is true and then you can quote yourself for it being true. I mean, this is very similar to that. Your client is not the authority on whether or not the plaintiff is a racist or not. If we assume that, that's even relevant.
But if she believes that, if my client believes that, and that's and this is,
So
this is where.
okay, so your client believing that the plaintiff is a racist provide her with a defense to go out and say something that's not true against the plaintiff?
No, but it explains maybe potentially some. We're not saying that she's saying anything untrue, okay? Just for the record, what I'm saying is.
I know that, but I know that's what your contention is. But if we get to where it matters, there's been a determination by the jury that when your client has said it's not true, and then they try to determine, well, are there any defenses to that? Well, if the plaintiff is a racist, that doesn't provide a defense to go out and say something untrue about anyone, right? Under Georgia law?
Correct.
And so this video is your client providing commentary that, and maybe using some examples about why she's providing commentary to her belief that the plaintiff is a racist. That's not relevant to the claim of slander, intentional infliction of emotional distress, invasion of privacy, false light. It's not an element of any of those things, is it?
No.
It's inadmissible. It doesn't come in. I've got to serve a purpose. It's got to serve a purpose. But I'll tell you what, if it were me, this particular clip, if I'm the plaintiff, I let it come in because I think it supports everything about the malice that the plaintiff is alleging. The other one, I can understand the plaintiff not wanting to come in because it includes the mean stuff that the plaintiff said about someone else that she engaged with online. But this is just your client talking and demonstrating her maliciousness throughout. So it's not coming in. The plaintiff has objected, and their objection is valid. It's out. All right. So we have another video to look at completely, right? Oh, I didn't rule on the first one. The first one, let me go back and read my notes. All right. The first video we looked at in this sequence is also ruled out by the court. It's not admissible for any purposes. It's prejudicial and really has no relevance to the issues in this lawsuit. So both of these last two clips we've seen are not admissible. All right. Let's look at the next one.
Okay, the next one is there is one other clip in this video. It's very short, and I'll just explain the reference to your honor. When Miss Ismailova showed the video of my client with a towel on her head, she was getting ready. To my client, there was a limitation on what could be played from that video to keep out gang references and things like that. Part of that video is also in here, and I believe it's been edited to not include anything that the court said couldn't be in. But Miss Kibi does make a comment about this video later in this video about something like, and I'm paraphrasing from my notes, and I will play it in a moment. Something about plaintiff is going to lose her life. How are you going to raise your kids if you're out there jumping on people? We just want to make sure. I'm not sure it needs to be in here, but we just want to make sure also that this isn't parlayed into some ability for them to try to elicit any testimony about gang references or anything else from their client on the stand if this is played. 21:08 through 22 seconds. So it's approximately, I'm not going to try to subtract.
Whereupon a video recording was played.
So your concern is that you don't want them to use that to open the door for arguments about gang, or it's not even really how I interpret that clip. I interpret jumping on other people to be figuratively, by saying that stuff about people when they criticize you.
Yeah, I hear you, Your Honor. My concern is that, at every turn in this case with their counterclaims, they were trying to use that video as a gang reference. And yes, my concern is that I do not want them trying to open the door and saying, oh, they opened the door by letting her say that and trying to elicit some kind of testimony that went further than that. That is my concern.
Well, we're not talking about any contention that the defendant has that the plaintiff is in a gang. That is at best, and I put best in quotes, speculation on the part of the defendant. It's not provable in any sense, but it's based on evidence. And we're not actually talking about gang in any way. All right, go on to the next one.
All right. So the next one is the longer video. So just for the record, the for D34, provided it's authenticated, we're not going to have any objections to any specific time clips for this one. And then,
Could I briefly object to that, Your Honor? That D34 is the video of the beer bottle that I thought.
It's coming in.
I thought the plaintiff had already said it's coming in, so I don't know what she's provided. What this provided its this authenticated thing is.
She's not objecting to it.
Mm-mm.
so I'm assuming they're going to show it to their client and say, is this the video you saw on the internet? And then she's going to authenticate it. So if she authenticates,
By authenticated, then this is the video I saw that I relied on when I said what I said.
yeah, it was on their pretrial order list, but it was not.
I'm not sure that we're arguing about anything. Is the defendant going to play the video?
Yeah, we are. I just want to make sure that we remember that what they said at the pre-trial conference about this video.
That what?
That they're not going to object to it coming in because they know.
I don't think they were objecting to it.
Okay.
Is the plaintiff objecting to the Pornhub video coming in?
No, as long as she authenticates it and says it's a video she saw.
Yeah, I'm sure she's going to.
Obviously.
I'm not saying we didn't have it when we deposed her. So that's all. Assuming that happens, we don't have an issue.
I don't think we're really arguing about anything here.
No. And then just to get it out of the way for P592, for the specific 28-second clip that they're playing, we didn't have an issue with that. I actually think I already played it for the jury. So that's not an issue. So the last one is P531. And so this was not actually on their pretrial order. This was on ours. We did not introduce it, however. Obviously, at the time we made exhibit lists, we didn't know what was coming in and what wasn't coming in. And there was I'm not going to explain the purpose that we were potentially going to use this, but it has a lot of highly prejudicial stuff throughout the beginning. And it's essentially it's Miss Keeby talking about at the very beginning, she makes a comment about Azalea Banks saying that my client has cold sores and that Azalea Banks called my client ugly without makeup and looks like a big toe. But the issue is that beyond that, then she goes on to essentially read, and I don't know what she's reading from, but read some back and forth online between allegedly between Azalea Banks and my client, and again brings up all of this, racial undertones and essentially calling my client, she's kind of calling my client racist and reading that Azalea Banks is saying. So the entire piece in the middle, it just doesn't have any relevance to this case. I don't know what it could possibly be relevant to other than them trying. Well, that's not relevant. I don't know why they're trying to play it other than to just prejudice the jury and introduce other online, other incidents with completely unrelated parties that have nothing to do with this.
So you talked the beginning and you talked about the middle. What's on the end?
Oh, at the end, there's a small trailer where she's plugging wine and using it as an advertising platform.
All right. So let's start it then from after the Azalea Banks discussion about the cold sores or the makeup. You've already said what you already said that's been played. Started from that point, that has not been played.
I don't think it's been played. It's been mentioned. That was not played.
All right, let's just start it from the beginning then. How long is it?
It's 18 minutes long. We get to the part at the end at about the 15-minute mark and the part at the beginning where
I'm sorry. You get to what at the 15-minute mark?
the part about the advertising.
Okay.
Really the only non-objectional piece.
Mm. Okay. Well, the stuff about the code sores or whatever, are you saying that's objectionable?
This video was not on their list, so we're objected on that ground. However,
It was on your list?
no, I understand that, but that's very short at the beginning. It's like around the 28-second mark. So if that was all they were playing, maybe it would be relevant. Why don't we just play it?
Other than the part about the plaintiff's appearance that arguably would be supportive of a claim that she had herpes, what is the reason for the rest of the video, Miss Ismailova?
Your Honor, I don't know if you recall. I had asked the plaintiff when she was on the stand about her online feud with Ezriela Banks, and that is this video just is proof of that feud. It's like them going back and forth with one another, and then the plaintiff
And they're going back and forth about what?
about like they're just going back and forth too. It's like long, very long messages.
But what's that relevant to?
Well, because in some of the messages, SVL Banks does state, that the plaintiff has cold sores allegedly.
But beyond that, what's it relevant to?
I mean, nothing really, just except again the further version of their online feud, and then after that,
Their online feud, who's there?
the plaintiff and Ezriela Banks,
But
Azelia.
what is that relevant to? I mean, that's my point. What does any feud that the plaintiff has with as Azalea Banks, what is that relevant to with the issues in this lawsuit?
I'm sorry,
What is it relevant? The plaintiff's so-called feud with Azriela Banks,
Azelia, Azelia.
Azalea Banks. what could that dispute have relevance to that's in this lawsuit? Slander, intentional infliction, invasion of privacy.
The slander, because the testimony that came out was that my client was the first person that, that said that these things about the plaintiff. And that's not the case, as shown by this, because this happened before the Cyber Marie Jones interview had came out.
Okay. As it relates to whether or not she has herpes
Yeah.
at the beginning of the video, but the rest of the video, does that have anything to do with the issues in this lawsuit?
Well, I mean, it shows the interview that Azalea Banks did with Breakfast Club, and the plaintiff, I believe, stated that Azalea Banks apologized to her, but that video does not disprove that testimony. Basically,
Still trying to understand the relevance. What's it relevant to as far as the plaintiff's claims against your client? Not about the code source, but other stuff talked about. How is it relevant to whether or not your client committed slander, invaded her privacy, or intentional infliction of emotional distress?
I mean, I think that the part that's relevant is about the cold source.
Then let's see the first. Let's play that.
Sure. I believe it's like a 2 or 3 second clip starting around second mark 28, Your Honor. And Your Honor, just one quick thing. This does not show the interview Ms. Ismailova just mentioned, and that's actually not the testimony my client gave about Azalea Banks. But we can get to it if we have to. Go ahead.
Whereupon a video recording was played.
All right, so that's the end of that.
Pretty much, Your Honor. And I mean, my client already admitted that that happened on the stand, but
Well, that can't pretermit its introduction necessarily. So that part, I don't have a problem with it if the defense wants to play that. Just go ahead and play the rest of it.
Whereupon a video recording was played.
How much longer is it?
we're at 10 minutes. It's about 5 minutes longer.
Okay, anything more? I mean, is it the same?
It's more of the same talk, but she goes into talking about more of the racism and more of her opinions about being racist.
All right, let me do this. It just dawned on me that we have not taken a break since we've been in here, and I'm sure plenty of people need a break. So we'll take a break and we'll come back in 10 minutes.
Your Honor, just one thing. I just wanted to correct one thing I said. It didn't contain a clip from the Breakfast Club interview. It didn't contain a clip where she said the part about cold sores. So I just wanted to make sure it was clear with the court.
I'm sorry, I don't understand.
I said it did contain clips from the Breakfast Club interview. It just didn't contain the statements from Azalea that she said cold sores. Cold sores. I just wanted to make that correction.
All right, thank you. So 10-minute break.
All rise. This court is in recess for 10 minutes.
All right. Would anybody like to have a bathroom break?
Mhm.
Well, anyway, I would like to introduce to everyone the individuals who have channels on this channel right now. Our judge, her channel is the only male cruise channel, and someone I'm sorry, the mods, could you please put Mel's channel in the chat, please? And also we have Purple Couch. Purple Couch, what's your chat? What's your
Um,
channel?
Speaking from the Purple Couch.
Speaking from the Purple Couch. I always mess up her name, so that's why I can't get it right today. And anybody else has a channel? No, right? No one else? Okay. So please, guys, please go and subscribe to Mel and Purple Couch channel, please. These guys are some excellent, excellent, excellent readers. So please, guys. All right, guys, y'all ready? Go back. Ready? It's almost over.
Okay.
Yeah.
Let's go.
Brief recess. Thank you. You may be seated.
Please be seated and come to order.
Okay, so on a couple of matters, we're going to continue with the trial. We're going to excuse Miss Richardson, and we're going to continue with the 8 jurors that we have, assuming that the jurors are all comfortable moving forward with the case. If I have any jurors that are not, then we would take a time out of the trial and come back to it relatively soon. But I can't say exactly when that will be. I'll have to look at my calendar and see when it would best fit. As it relates to what we've been talking about this morning, one thing that Ms. Ismailova said sort of at the beginning of our colloquy about the relevancy of some of these videos, and I'm going to be paraphrasing what she said, but that essentially is it's important for the jury to understand who the plaintiff is as it relates to the issues of damages. I think that's probably right. The plaintiff that testified on the stand is not certainly the plaintiff in the videos, not the same person in the videos that I've seen so far. The snippets, not seen a lot, but there's been some. And while I don't, particularly listen to hip hop or rap music, I do sometimes. And so I'm familiar with her work generally. And, it's certainly edgy stuff. I really do like the Bruno Mars video. That's my favorite one, probably because I really like Bruno Mars. I hope to get to see him one day in person. Um, I've never had that chance. He kind of reminds me of Michael Jackson, just of a different generation in a lot of ways. So I guess my point ultimately is that the videos I've seen that have been introduced, some of the stuff that is out there in the music world that I'm privy to is different from the plaintiff's demeanor here testifying. I certainly recognize that. I think, as Ms. Matz had argued maybe once before, that, we're talking about art. Music is art. And a person's persona in the business world and the art world can be different than who they are. But it's really not my decision as to who the real or what the real persona of the plaintiff is. She can be hurt the way someone else might be hurt. This is for the jury to decide. Now, I could say similar things about the defendant. The defendant that has testified in this case on the stand is quite different from the defendant in the videos, really markedly so. I don't know where Miss Kibi went to high school in Panama City, but I have relatives that live there. And I suspect that, some people in her hometown probably do not recognize her when they see her in videos, given how they knew her when she grew up, knowing the generally conservative makeup of that place. So here's my point ultimately. Long way of getting to it, I know. But what the defendant may have said about the plaintiff, about whether she was racist or not, whether she likes Black people generally, whether she deemed some other person or client or customer or other person on the internet a fan of hers, isn't relevant, and it's not admissible. And I'm not going to admit those things. Like the whole wide video we just saw is not going to come in because it's the defendant talking about the plaintiff. But I'm not going to exclude the text. The text I'm going to allow in because I think it's important. If the defendant can find out how to make them admissible, then it does set the stage about who the defendant might, the plaintiff might be. And it does feed into the defendant's argument about whether or not the plaintiff was hurt when the things that were said about her were said. So, in other words, let me put it this way. If the text, including the one that talked about the first one we looked at, the one that used the word monkey and such in it, if those texts show a place where the defendant might live quite different than a place that the person she appears to be in court, and the jury might look at those texts and say, well, okay, so really that stuff was said about the plaintiff that wasn't true. That would be harmful to me as an individual, but maybe not harmful to the plaintiff, given the kind of persona that she projects out there. The jury might say to the human being, like anyone else, and human beings have feelings, and, nasty negative things are said that aren't opinion based, but are fact based, and, such that maybe the jury determines that they were liable per se because that's an instruction that the plaintiff has asked for, that yes, she could be harmed like anyone else. But I can't cut the legs out of the defendant from making their argument, and I'm not going to do that. So I'm going to let the text come in, but not the video talking about the text or the plaintiff talking about the text. Now, defendant has got to find a way to make them admissible. And that's not my job there to help you make that case. Yes, ma'am.
Your Honor, when you say text, would you please?
The text of the Instagram, whatever they were, where the plaintiff was responding to people and saying things that you think cast her in a different light than the image she portrays in court.
Okay, so far from the Instagram that was in that one video that we just saw where my client was wearing the yellow shirt.
That's one. And you also had another one. You also had the one earlier, and I don't remember where were those long texts. What was that first one? What was the one that used the word monkey in it? Instagram comments, things that she may have said, but you got to find a way to make them admissible to use them. All right? Yes, ma'am.
Okay. Just those two Instagram comments. I just want to make sure I'm clear on what you're ruling.
Yeah. The things that can be directly attributable to the plaintiff that haven't been said can be admitted. If you can lay foundation to admit them under the rules of evidence, you have to do that. You can't do that with your client saying, I saw these. I mean, you have to say, I guess really there's only two ways to do that.
Call the plaintiff.
You can call the plaintiff or you can call the people that received them from the plaintiff, which I can guess is not going to happen. The plaintiff denies that those were hers, then they're not admissible. I mean, I can't make an independent determination that they're authentic unless I have evidence that they're authentic. You also, I've been presuming that you're going to play some of her music videos as well. Maybe you're not, but I had assumed that you are. I think that does kind of the same thing. But if you choose not to, that's not my, that's none of my business. All right.
I do have another follow up question, Your Honor. Sorry, because initially we thought that the pretrial conference, those screenshots of those texts was ruled out. And so they're not on the exhibit list that Your Honor has before you. So, how do you want us to, if we do want to introduce them, do we just submit another exhibit list or do we just?
I'm going to these are, if you can lay a foundation, there's only one way you can do it. And that's with the plaintiff admitting that they're true. But they're not a surprise to anybody. It's not like new information. So I'm going to let those in, but you've got to lay the foundation.
Okay.
All right. And so we're going to continue with the trial. I'm going to call the jurors out. I'm going to, apologize to them for the delay this morning and then engage in a colloquy about the juror. Okay?
Your Honor, do I have one more?
All right.
Question. I'm sorry. After you do the
Colloquy.
colloquy, we'll be, I don't know what I'm resuming or
Resuming, assuming that we can.
where our request and Your Honor would entertain this would be to allow us to redact the rest of the stuff that was ruled out today, just because I know that the narrative has been spun that we're trying to throw this trial or we're trying to get a mistrial, but nothing could be further from the truth. We do not want to try this case again. We want to be done with it this time. And our concern is, even if we have the timestamps, if there's something, a technology glitch or something happens, and for some reason that inadmissible stuff comes in, we're not trying to do that. So we would request, if Your Honor would entertain that, to give us just the text today, would be ready tomorrow. it's not that many cuts. We're able to do it, but we would.
Okay, you have other, I mean, it's 1:30 now. By the time I finish questioning the jury, it will be sometime after 2. How long, other than those things, you don't have other things you can ask your client and then come back to the videos?
Really, it's just videos. Really, it's just the video is the majority of her testimony.
Okay, what about her husband? Are you going to call him?
No, I mean, not as of right now. We're not planning on doing that,
So this will be your only witness then?
with the exception of that what Your Honor just stated. We might recall the plaintiff for those specific texts, but that would be yes.
All right, let's talk to the jurors. Let's go ahead and get them out here, and we'll figure out where we're going to do after that.
Thank you, Your Honor.
Your Honor, I was just going to say this is obviously up to you, but I don't have any objection to that because we obviously want to make sure that there aren't anything that shouldn't be played to the jury either. So just putting it in Your Honor's head.
Yeah, I understand. Thank you.
All rise. Whereupon the jurors entered the courtroom. Please be seated and come to order.
All right. Good afternoon, ladies and gentlemen. So we've got a good bit of things we need to talk about procedurally. The first thing I want to do is apologize for not being ready for you when you got here. I had anticipated that we would be finished with our discussions on some evidence by the time you got here, and that just wasn't the case. And indeed, we're not really quite finished yet. I've made some decisions on some things that is going to require the lawyers to do what we call redaction. Redaction is going back and looking at some of their evidence and making some changes. Sometimes, if you think about it, a letter might be introduced into evidence, and there may be certain lines of the evidence, lines of the letter that are blacked out because it includes material that was not properly admissible. But there's other things in the letter that was admissible, and so we black out what it is if you shouldn't see because it's not admissible, and then we'll let you see the remaining part of it. It's kind of like, if you would like to think of it, it's kind of like when we go over to the sidebar and we talk about stuff, hoping that you don't hear us so that we can figure out what it is that you should be able to hear so that you don't hear things that you shouldn't. And so I've made a series of decisions that I really can't go into in any detail with you about now. I could certainly talk to you about it after the case is over, with just so you have a complete understanding of it. That's going to require that there be some additional work by the lawyers to do some redactions to some of the evidence so that we make sure that you see that what you see is, what we intend for you to see and not the stuff that we think you should not have to put before you. So that's one of the things we need to talk about. And we've been talking about it this morning. And it's why we've been delayed. And it's why we're not really yet ready for you now. And so, assuming that we continue tomorrow, then you would, well, what I'm going to ask you to do is come back tomorrow. I recognize it's a hardship. I know some of you have driven a long distance, and I wish that was not the situation that we found ourselves in. All I can do now is apologize and tell you I mean it. I had a witness yesterday in another case who wrote me a long letter. It was a doctor who he wasn't happy that he came to testify in a trial I had last year where he was put on the stand about 4:30. He really didn't want to answer the questions very forthrightly, which meant that he and the lawyers kind of danced around with him being very evasive. And so the next thing you know, it's 5:10 and he's not finished. And I sent the jury home and told him he had to come back the next day. And he was not happy with that at all. He pitched a fit in front of the jury. And then the next day, when he came to court to finish his testimony, which only took 30 minutes, took 30 more minutes as it turned out, but he was much more compliant when he answered the questions. He still obviously wasn't happy because he wrote me a letter over Christmas. He didn't cuss me out, but he did without cussing me. You know what I mean? So, I just said, look, I don't control as the judge. I don't control what witnesses get called or when they get called. The things that I control is the times we're in court and what's admissible and what's not. So that's not going to, I sent him that letter yesterday in response to his letter. And he's not going to be happy with that either. I'm not happy that we essentially wasted your time today by having you come in when we're not ready. But I would rather send you home without hearing any testimony today, just so, again, that we're able to complete the trial and minimize any mistakes. The other thing, though, that I do need to talk to you about is the fact that there's only 8 of you here today, and yesterday there was 9. The juror who's not here or not with you is the juror. I didn't identify her last time because I didn't really need to, but that's the juror whose son had been exposed to COVID, or it was COVID. And she had thought she had limited exposure to him. And it turns out this morning or overnight, she woke up and she had COVID symptoms. She, told us about the COVID symptoms. And so we instructed her not to come in today. Let me tell you what I'd like to do. What I'd like to do is continue with the case without her. And the reason I would like to do that is because I can't predict the future. And I don't know, when any of this will be, when any of us will be exposed to COVID and when we might have delays in the future. But I say that as a person who had COVID now 2 weeks ago. So I'm not really, and I've had both shots and a booster. And, that I've had a mild case, that really was something that for me was nothing more than a code, which, I'm 58. So I attribute that fact to the part that I can control, which is I've done things that I can do to minimize it. But, I don't know any of your personal situations and I'm sensitive to it and I want to be. I can't say that any of us are going to get COVID because we were exposed to someone who might have COVID. We don't know whether she does or doesn't at this point. She has not been tested, but, like I said, I would unless some of you are having COVID symptoms, I would like to continue. But I want you to tell me what you want to do. And I don't want that to happen where you have to stand up in court in front of everybody and say, Judge, I'm comfortable, or Judge, I'm not comfortable. So here's what I'm going to let you do. I'm going to let you go back to the jury room. Everybody has got paper and pencil and pen. You can tear off a piece of paper, write your name on it, and tell me, yes, you're good to continue with the testimony tomorrow, or no, you believe we ought to take a break and allow the situation, to resolve itself with the other juror, and also see if any of you might test positive or have symptoms, really. I'm not going to share the names, your responses with anyone on an individual basis. If some of you write down that you're not comfortable proceeding and you would rather take a time out of the trial, I'm going to honor that. So even if one of you wants to take a time out, then we're going to do that. And I'm not going to tell anybody who, which juror or which jurors decided they want to take a time out. If all of you are comfortable with continuing, then we will continue in the morning. So do any of you have any questions? You write yes if you're good with continuing with your name on it, and no if you're not good with continuing. And understand, we'll take a break for about a week or 2 and come back and just pick up where we left off. I'm not sure if it will be a week or 2 weeks. It will be sometime between a week or 2. Now I have to go and check and make sure that we've lasted a long enough time to allow if there were any effects, if the other juror does have COVID, and if you've been exposed to it, that has kind of run its course if we're going to get it. So, so we could know or wouldn't be back or know where you're coming back or, I do recognize, COVID is here and it's going to be here probably, some of my age, probably for the rest of my life in some form or fashion. And there's no guarantees that when we come back, we won't have similar scenario. But I do want I want all of you to be comfortable in the procedures that we're using to try to keep you safe. And so I'm going to defer to any of you if you decide you need to take a break. And if you don't need to take a break, feel like you're ready to go forward, then we'll do that. So accept my apology, please. And when the trial is, as far as the delay today and yesterday afternoon, if you want to know about the particulars of that, when the case is over with, just ask me and I'll tell you. But until then, I really can't go into the detail, or I'll be telling you stuff that we're talking about that we don't, you know, we think you would be, well, that I think at least, there were some modifications that needed to occur to some of the evidence that might come in. So I'll let you go back to the jury room. You can write your note. I'll send word with you about whether or not we're going to continue tomorrow or whether we're going to take a break. If we continue tomorrow, then you could return tomorrow morning at 9:30. Okay? So write your note, fold it over so nobody can see it. Let the court security officer know once you've done it. They'll bring the notes directly to me. I'll read them and then I'll tear them up and throw them away. Okay? Thank you.
All rise. Whereupon the jurors exited the courtroom. Please be seated and come to order.
Anything else we need to talk about in the interim while they're doing this?
Oh, um, I have two other. I have one question, and I'll just maybe two questions. One is with relation to the ruling about the internet piece of the, what is herpes and the thing Miss Kibi pulled off the internet that's going to be shown to the jury. Could we just get the same limiting instruction, just hearsay, when that's played as the Facebook post?
Okay. That was played when she was, I don't remember. Now I can't remember the other stuff that was on there. We said the video was, did I say the video was admissible?
Yes.
You did, and she pulled up, something. I don't know what website she got it off of.
Yes. So you'll have to remind me of that when that goes to be played.
I will. Absolutely, Your Honor. And then the other question I had is actually a weather question. I've heard that there might be ice tonight. Can we just know if there is, how?
So I haven't heard that tonight. I've heard that Friday, maybe Thursday night overnight into Friday, there could be an issue, but not tonight. So I can check and see what all that.
I'm sorry, Your Honor. It is Thursday night. Sorry.
Okay. The last I heard on that though was actually that it was pushed until Saturday.
Okay, great.
And right, then they really weren't expecting it to be anything. And if it was something, it may be Middle Georgia, not North Georgia.
Okay.
Let me see. Okay, all right, let's see. All the jurors have confirmed that they're ready to begin back tomorrow morning. So we'll be back at 9:30 in the morning.
Thank you so much, Your Honor.
All right. Well, see y'all then.
Thank you, Your Honor. Thank you, Judge.
All rise. Court stands in recess, whereupon the proceedings were adjourned at 1:55 p.m.
Whew,
Woohoo.
Oh my
What a
God.
day.
I tell you.
Hey.
Ooh,
All
let
right,
me let,
ladies and gentlemen, how did you guys like what happened today? It was a lot of
mm,
laws
Administrative.
and
Isn't this their recess again because Olga didn't have all her stuff together and she was supposed to have together today? So they had
exactly.
to redo
mhm.
it and recess again and start over again the next day.
Well,
Yes.
it seemed like she was still trying to slide in some new stuff
Yeah,
too,
Correct.
Mhm.
yeah.
and make new arguments on the side.
Mm-hmm.
Ooh.
Man.
The judge is
Wow.
super patient though. Y'all can tell I'm
Yes.
acting. I'm not that patient. Ooh, wait.
Yeah.
My
And I mean,
goodness.
and he was really trying to be fair
Mhm,
and not biased and really weighing things, and really,
mhm.
talking it out and
I think too that the judge really wanted to make sure that the jury was understood that they were appreciated. Now that is that. Now that part is me. I'm like that.
mhm.
They really wanted. I feel like he really wanted the jury to know that he respects their time and respects the commitment that they've made to, doing this jury duty. So he was really very respectful in that regard.
Yeah.
Definitely.
Yeah.
And it seems like he's been extremely thorough to ensure that the verdict sticks, to ensure that there's
Absolutely.
not a reason to change it.
Yeah. Very
Yeah.
Right.
conscientious.
Yeah,
But
he
oh, I'm sorry. Go ahead, girl. My bad.
Oh, no, I was just saying because he definitely doesn't want a reversal. and if it happens to make it to the appeals court, he wants it to be affirmed.
Absolutely. So, I wish, and I don't know if there's more to this, but boy, I appreciated Sabak being gone off on. Say it one more time.
But you heard what he said. Did you hear what he said to Olga about that school things? You see, we didn't lie, did we?
Y'all did
No,
not
you
lie.
didn't
Y'all
lie.
ain't told
Nope.
not nan lie.
Nope.
But I'll tell you something I think Tasha told the truth about.
What?
That rating she gave her attorney.
Oh, oh yeah, yeah,
That internet rating. She didn't. She
yeah.
told the truth. She told the truth on that one.
Man, this is
I can't believe Olga.
wow. And okay, you're gonna try to prove that she don't like black people if she married to a black man, child half black. I don't
Look,
know.
this must be a wino right here. Look.
What did it say, girl? What it say?
I hope y'all keep the same energy for CNN and Fox News.
We absolutely will. Shoot.
Absolutely
Why
will.
would we
We
not?
do all the time. That's why Sylvia
Right.
does what she does.
Come on. These are
Hello,
transcripts,
hello.
boo. What's T?
Yep, official transcripts
Come on. What you talking about?
available.
Somebody, court deputy, read the last line of what the court reporter says on her in regarding to her transcript.
The last line.
Like the last sentence she says.
What line is it on?
Where she tells you about the accuracy and things like that.
Okay.
At the last page.
Starting on line 7.
The last page of the
Yeah,
yeah.
line 7 sounds good.
Yeah.
That I reported on the, what is that called?
Stenograph machine.
Stenograph machine. The proceedings held in open court on January the 19th, 2022, in the matter of Belcalis Marlenas Amazar versus Latasha Transrena Kibi and the Kibi Studios LLC, that say proceedings in connection with the hearing were reduced to typewriter form by me, and that the foregoing transcript, volume 6 of 10, pages 1 through 100, is a true and accurate record of the proceedings.
Come on.
Thank you.
Mhm.
So even when
Accurate.
yeah, and even when we're reading these transcripts and they're saying like, well, and I and ooh, that's in the transcript.
That's in the
Right.
Transcript, and people got me complain. Oh, look at them how they read. No, it's
Yeah,
in there.
trying to make them sound
Yeah,
That's
it's
right.
in there.
So
And
I'm sorry.
I will add that Olga trying to say that she's racist. Why, if she was racist, and that's the reason why she was suing Tasha K, why did she drop it with Azalea Banks? Because
Right.
Azalea Banks apologized per Cardi's earlier testimony.
Right.
And Azalea's
And
also
she's married to a black man. Hello.
Yeah.
Thank you.
With a mixed child.
But see, that was just further proof of her pulling straws. But I think that uh, Olga thought that she was going to be able to come into court and the judge was just going to just lean in her favor. Well, see, because even her arguments were so horribly presented. Well, see, like sort of, I'm
Yeah.
saying, I guess,
And I don't know. And
yeah, you were so unprepared. And then
Yeah.
that sidewind and stuff she was doing, like, well, Judge, like, it kind of goes to it. They wanted to admit things that made Kibi look worse.
You're right.
And why did those attorneys not realize that?
And the judge was laying it out there for them. This is the possibilities of how the jurors will see your client if this is admissible. So think about this. Think about this. And they're still like, oh, yeah, okay, yeah, but we still want to admit it.
But in Tasha's mind, that did not make her look bad, because keep in mind, everything that Olga was going to present, she and Tasha already went over it. So Tasha had to bring those to her, and in her mind, it did not make her look bad.
Mm-hmm.
In her warped mind.
Mm-hmm. And the sidewinding piece of it was, well, we just want to make sure that, y'all get to see other aspects of Cardi. But that was so not relevant. You see how the judge kept saying, how is that relevant? How is that
Mm-hmm.
Cardi's
relevant?
not on
Right.
What is
trial.
relevancy?
Right.
And it was intentional. Well, we just want to show you that it's like they were trying to say she deserved to be
Right.
spoken about and treated the way she was treated over the internet. So now we want to show
Right.
you why she was deserving of that.
Right.
Oh
And
my
then
God.
too, they're, not that what Cardi stated as far as calling the baby, a monkey, whatever, but also it was a whole back and forth. The lady talked about Cardi's niece, and I mean, and so they're not like showing the complete picture either. I mean,
Hmm.
yeah, she could have used different words to get
But
back at her, but I mean, come on.
if I understood that evidence correctly, was what they were trying to was that wasn't even Cardi in there typing it, right? Wasn't that commentary from the people in the comments and not necessarily Cardi?
Yeah, some of those things was.
Some of it was, yeah. Oh my
Um,
gosh.
mm, mm, mm.
It's like really people. It's just amazing to me. I'm just
And then had Cardi keep on talking about that she's talking to, well, not Cardi, but not Cardi, but the August keeps saying that obviously she's not talking to herself. Like Tasha one time, yeah, she do be talking to herself because she don't care about what nobody else says or thinks. Who she? Obviously, she's not talking to herself, and she's talking to her audience. No, she's talking to Cardi.
Yeah, she
Mhm.
she was she was unprepared, unprofessional, and very disrespectful.
Yeah. Wow.
Well, thank you, everybody. Thank you for your time. Thank you for being here. We will continue tomorrow for our next set of the transcript. We should be finished really soon, guys. The way we're going really pretty quick. And I thank everyone on the panel for your time. Thank you for the reading thing. You guys are awesome.
That's
I'm
you,
telling you,
Malcolm
when
Selby.
look, when we go to Broadway or wherever we go, I'm gonna take you guys with me.
I
You're
don't
gonna
want to
be
go.
right there.
I
I
don't
just
want to
have
go. I
one
don't like
question.
reading.
One question. Was Cardi and Tasha sitting there this whole time for this?
Yeah, we were all
Oh,
there.
wow.
The only person who wasn't there was the jury.
Okay.
What
Wow.
time tomorrow did you guys want to do it? Do you want to do it a little earlier, 8 o'clock, or still the
Yes.
9 o'clock? 8 o'clock.
Yes,
Okay.
please. Yeah.
8 o'clock tomorrow, guys. 8 o'clock tomorrow.
And real quick, what was the makeup of the jury? Jury was it?
Only one black guy, and the rest was Caucasian.
Oh wow.
Jury.
Also, I wonder if I wonder
Well,
if
it
that
was a
made them
mixed.
think.
It was a mixed lady there too, but
Mhm.
majority.
I wonder if they thought, oh yeah, we're really gonna win. If Kibi and them thought they were really gonna win.
Yeah, they wanted to keep the jury. There was one juror. Remember, she said when she heard that the way that Kibi was talking in front of her daughter and the language she was using, and she said she could not be unbiased, and
Mm.
she was already it was like okay slander already, so,
Right. Wow.
so she just couldn't do it. How old were they, Sylvia? I would say the juror was an older crowd. The guy, he was younger. He was about like 45. But there was several retired, like about four retired persons on the jury. It was one white guy, no, two white guys, and then the rest were white women. No
I'm not
black,
sure
no
why
black
they
women.
thought, yeah, why would they think that would go over well with all the vulgarity?
It was terrible. It was really bad language.
And basically she put it in their hands. She said, let the
Mhm.
white people decide.
Well,
Oh yeah, she
I
did say
know.
that, didn't she?
Yep.
She did say that. She got what she wanted.
Thanks.
Yeah. But 8 o'clock tomorrow, ladies, I will be sending you guys the new transcript because we completed this one already. So we'll
Okay.
be ready to go.
Mhm.
And I will do more of the thank you everybody for showing up. We tonight we did not have Cardi or the attorney in the chat tonight, but maybe tomorrow we'll have them.
Mhm.
All right. You guys have a wonderful night. Good night. Thank you, everyone,
night.
again. Thank you for
Thank
being
you.
here. We're almost done with this.
Yeah.
All righty.
Thanks everybody for pulling up.
Yeah,
Uh,
that's great.
all
And thanks
right.
everybody in the chat.
Absolutely.
Thank you. All right.
See
And
Thank
y'all
Miss
you.
later.
Sylvia, as always, thank you
And Miss Sylvia,
Oh,
being so
yes, on the
diligent.
case.
Yeah.
Yes.
nah, it's
See ya.
nah. It's part of the job, y'all. It's part of the job. All right. Good night, everybody.
See ya.
Stay here, board. Okay. See you guys. Bye.